There are really a number of things. For example, if you are subject to any of the thousands of regulations that are out there, in the UK, there are Financial Services Authority requirements, the things like the EU Markets and Financial Instruments Directive and so forth. All of those require you to retain data, to make it available. If you ever have to go through a regulatory audit, if you ever get sued, you have to go through the e-discovery process. And one of the fundamental problems is that if you have, something like Dropbox, again, a very good tool, but one that's completely outside of IT's management, then as a corporate decision maker, as legal counsel, as the person charged with gathering up all of this information and searching through it and presenting it to the regulator, for example, you can't get into all of those private Dropbox accounts. Yes, you can, individually go to each one, extract the information you need, but if you're in an organization of 500 or 1,000 users, that becomes very impractical, and it takes just a very long time to do it.
And if your employees are using personal file sharing tools and something happens, there's a breach, a security breach, you could expose yourself to tremendous legal and financial exposure. I mean, it could literally cost your company millions of dollars depending on how severe the breach is. So that's, in its most basic form, that's the risk. There's also what I call headline risk, where if you're a large enough company and the breach is egregious enough, you can wind up on the front page of a national newspaper. I mean, in fact, we're seeing this happen weekly, if not daily. And I would also add, there are risks here that may not be obvious. So as we talk about employees using things like commercial mail accounts or cloud sharing services, what some folks may not realize is that many of these third parties get their money through advertising. And as they move from blanketed advertising to more targeted advertising, what they're actually doing is scanning the data that you are uploading or that you are transferring. So that file that you think is secure and that nobody's looking at, in fact, is being scanned and is being used to target you and other users. So already, just by virtue of using one of those services, you could be in breach of some of these regulatory requirements. So there are a whole number of risks here, financial and otherwise, that folks really need to be aware of if they don't have as part of their infrastructure a business class file sharing solution. I wouldn't say it's fear as much as an epiphany. It's something that they didn't think about or didn't get, and all of a sudden the light bulb goes off, and it's, we have an exposure here, and we need to do something about it.
Basically, e-discovery is the searching and production of information that you might be required to produce in a lawsuit. As an example, if you are a defendant or a plaintiff in a lawsuit, the other party can say, okay, we want these documents, these emails that were sent between these individuals, between these dates. We want these word processing documents, these policy statements, these, spreadsheets, whatever they might be. And if the court orders an e-discovery or production, then you are obligated to provide the other side with the information that the court has approved and that they've requested. In the United States, at least, you have a relatively short period of time in which to do that. So you need to be able to search across all of your repositories, all of your file servers, USB sticks, desktops, wherever that data might be, and produce that in response to the order. The problem comes in when you have lots of different repositories that are not under IT's control. It's very difficult to get to those. And in many cases, IT wouldn't even know that those repositories exist. So you run the risk of spoliation of evidence, because you simply didn't even know you had a source of information that was discoverable.